Speak up. Can you hear me all?
Yes, ma'am.
Okay. Okay, so today's discussion topic is Introduction to Business Law. Okay, so we'll today discuss about the Introduction to Business Law with the reference to Bangladesh legal system. Okay, so we know that the legal system is a set of rules for conducting any application or any activities under the performance of legal system under the performance of different acts. Okay, this is the legal system. So in every country there are some legal systems, legal rules that should abide by the citizens of that country. Okay, so law is a body of rules. Law is a set of rules that should be maintained, that is obliged by the citizens of that specific country. So the main purpose of different law is to govern the society, is to set the society people in a way that they will abide those rules. They can be maintained under those rules, and the society will be well mannered, well shaped, and the people will be well behaved. And if the breach of any law can be found by the governing authorities, then there will be some punishment, some rules for minimizing the losses, or how to compensate the other party who will take part as a loser of that breach of contract. Okay, so they are made by governing authorities. These governing authorities may be the partnership. These are there are different acts, these which are applied in the different scenario, whether it is contract law, whether it is partnership law, whether it is company act, whether it is act for trade, act for license, act for different intellectual property rights, any other business issues. Okay, so but these rules can be implemented by judicial authorities and the higher authorities who are obliged to implement those rules under the specific set of contracts. Okay, so meaning of business law, it refers to the body of law that governs commercial and business activities, right? And it regulates the rights, duties, and obligations of the business and individuals. We know that in a business there are a number of partners, there are a number of stakeholders, right? So every stakeholders has different rights, also have different duties and obligations to that business or to that company, right? So if the company breaches law, if the partners breaches law, they will be punished, or they will have to face several measures that is under this law, right? So business law is a branch of law which is application to or concerned with trade and commerce in connection with various business transactions. What can we say about trade? Trade is the combination of export and import. Okay, this is trade. So when we see that two different countries are exporting and importing between the countries or among a number of countries, this is trade. In export and import there are several laws, and if the laws are hampered, they will be and the company will be punished, right? So, in this trade pattern, you see that the apparel industry, chemical industry, or food industry, or fish agriculture industry all have to maintain those specific laws to conduct the trade among one country, among different countries and between different countries. So this trade also concerns how the contracts will be implemented in one country to another, because there are a number of countries who follows a different contract law. Okay, different law for because in religion we have Islamic law. In company act, it might be slightly different from the different banking sectors law, right? When this comes to the point of Islamic Sharia law, these are slightly different from conventional law. So these sort of things also happened in international arena. So every country not apply the same exactly same trade patterns, trade laws. Okay, so there might be some differences. So how they will minimize those differences, or how they will manage those problems if any breach of contract occurs. Okay, so they will settle under a common ground. And there are different laws for maritime laws, which covers the uh, seashore areas, or something like that. Okay, so business law includes all the laws that dictates how to form and run a business, how to start a business, how to buy products, how to buy raw materials, how to conduct relationship, maintain relationship with the suppliers, how to manage your business, how to manage the people of your business. It also includes the responsibility and duties of the CEO, or duties of the MD and the other parties related to this business, right? How to close the business, how to close the partnership, how to sell any type of a business. These all are included in the business law. It also relates to the trade. Just I have just explained it, how it is related to the trade, how it is related to the industry. Okay, apparel industry or any other industry. You see, the when Rana Plaza or Tazreen Fashion hampered, or when the COVID distracts or disrupts the supply chain, how this affects globally in the global value chain, and the global trade patterns, right? So these all are included in the business law, how to deal with specific situations. It also includes states federal laws as well as administrative regulations. Okay, you will find further that there are different administrative rules when it comes to the trade, because there are a number of specific set of rules on tax or tariff duties. Okay, tariff means what the extra amount we have to pay to import the product. Okay, usually tariff means, or tariff implemented on the imported goods. Some other exported items also have tariff, but very rare. Okay, so objective of this business law is to lay the framework in order to carry out the commercial transaction of the individual's partnership and partnership functions, right? So it helps the merchants avoid and settle their conflicts, because you know that all these activities are related and governed by the people. So people have different set of minds, set of perceptions. Also they have the different set of opinions. So there might any conflict arises. So how to deal with that? Deal with under business law, under law of that specific scenario. It has social objectives to serve the country at large. Okay, and it also maintain the equitable and exact distribution of wealth by preventing the concentration or any conflict that will be very bad for the economy, okay, very bad for the business, very bad for the society in the hand of few business houses, okay. Because if you don't have the law, and it's not only having the law, it's also implementing the law for equally for all the people. Law should not be differentiated for the higher class society people and lower class society people. There should not be any differences. All people are equal under the legislations of the law. So to balance the economic power, to balance the society's justice, to ensure the justice, social justice, all the governing authorities should implement the law or courts equally for the people of that country, right? Facilitates the business to achieve their goal faster, okay. So sources of business law in Bangladesh: the constitution of Bangladesh, right, which we call that সংবিধান, Constitution of Bangladesh. Statutory laws or act of parliament, parliamentary acts. We see that there are sometimes parliament verdict different law, different decisions under the consequences of that scenario, or analyzing the scenario, okay. Judicial decisions, where the judges provide the decisions, give a verdict, okay. So this is judicial decisions. Customs and usage, what is this? That customs is, there are social norms, social customs of the people, how the belief system works in Bangladeshi people, how they perceive it as a right and wrong. This is the social custom, okay. So sometimes different laws, when you see in the village, the members of the of a specific union, okay, specific village, they come to the point when there are different conflicts among the family members. They arrange a arrange a scenario, arrange a decision making point where the customs can be a part of source, okay. English common law, where it is applicable, it came from the country England perspective. So when it matches or applicable, then company and states can follow those rules, okay. Major business laws in Bangladesh: in 1872 Contract Act, those Contract Act uh, in 1872 also followed by Bangladesh. Though Bangladesh independence is 1972, the act was previous and it is followed as it is, okay. Sale of Good Act 1930, Partnership Act 1932, Companies Act 1994, and Negotiable Instrument Act 1881. Laws of contract, what is this? This is the branch of business law. Even it is based the business law. The Contract Act 1872 governs agreement enforceable by law. You will see that there are a number of laws which are established before the Bangladesh journeys begins, right? So these laws are exactly similar, or sometimes they are modified afterward. So when you find that the modified version, you will have to mention those, okay. As we all enters into the contrast of one kind of other or the other in all walks of our routine life. So, for example, when one buys or borrows any essentials, any items, any goods or services from early morning to late evening during the life period or during my journey of life, one naturally enters into contracts. How? Because we cannot see or we cannot analyze every sort of contracts, but when it comes a big issue, the contract is visible, okay. So when you see that you buy small pieces of bread home appliances, clothes, books, we don't actually analyze or perceive those in depth contracts. Okay, we just give the payment and maybe a receipt we can take, and a very simple contract, and this contract closes. Okay, just for 2 minutes. But when it comes to real estate business, or when it comes to partnership business, when it comes to a company, the life of a company, the life of a real estate business is huge. So though in those situations, the contracts and the depth of maintaining the contract is very higher. Okay, so in our daily life, to a very big portion, the contract regulates all of us. In business, at every moment, there may be a transaction that gives rise to a contract, right? The law of contract is fundamental to the existence of the business world. Without law, without the course of conduct, right? No companies can maintain the boundary of what is right and wrong. Okay, so without this, total business world as well as entire economic system may collapse if the countries do not follow the codes of contract, right? A contract is an agreement between two or more persons. Very simply, we can define it. A contract is an agreement between two or more persons, creating an obligation upon them to fulfill the activities, who fulfill the points, or not to fulfill some duties laid down specifically in an agreement. This is the contract, right? The agreement creates a legal relationship, legal boundaries of the rights, legal boundaries of the duties of the parties. Okay, all the parties engaged have to maintain their codes. Okay, and if these obligations in the agreement are not fulfilled, then several specific codes of conduct also be there, not taking this contract seriously. What will be the punishments of breaching that contract? Okay, so the defaulter parties and the other parties, oppressor parties, will have to compensate to uh, other party. Okay, laws of contract, agreement and enforcement by law. So when when any contract is legislative, and agreement, all the agreements are not contract, but all the contracts are agreement, right? All the agreements which are legislative by the law, this is contract, right? So every agreement and promises enforceable by law is a contract. Okay, in exchange of or promises between parties to do or absent from doing an act which is an enforceable by the court of law, judiciary law or company law or partnership law, any kind of law. Okay, so this agreement which create and define several obligations for the both parties among all the parties is law of contract, right? So you see the major elements of a valid contract, right? Agreement. There should be an agreement between and among the parties. Enforceability by law. Those agreement must be followed or must be supported by law. Enforceability of any law. At least two parties, and there needs a proposal, draft proposal and final proposal, and there needs to accept, both parties should accept those agreement. Okay, intention to legal relations. There are some legal bindings, legal relations, both parties should accept those legal bindings. And free consent, not a forced consent, not a coercive consent, aggressive consent. It should be a free, absolute free consent. Okay, contractual capability or capacity, because all parties cannot be under contract. There might different, like in partnership act, the people under the age of 18, they have a distinct version of contractual capacity. Okay, so all the peoples are not having same type of capacity for the contract. If actually if they are not the age of 18 at least. Okay, considerations, there might be several considerations, exceptional considerations if there happens any devastating losses, and where both parties are not responsible for that condition, right? Lawful objects and possibility of performance. Okay, every law of contract are an agreement, but every agreement are not law of contract. So it is an agreement first, then due enforceability by law. At first, the parties need to arrange an agreement, okay, accept an agreement. Then on that agreement, the law enforceability will be workable, okay, and then it will treat as a law of contract. So types of contract under Bangladesh law: valid contract that is enforceable by law, void contract that is not enforceable by law, just contract with mouth. Okay, so there is no written contract, no written codes. So these are not valid contracts. So if it should be a valid, if when it is valid contracts, there must be some codes, some written documents that should be under different set of laws, whether it is company law, whether it is a partnership law, okay, sole proprietary law, like that. Voidable contracts is enforceable at the option of one party. Okay, so both parties, you see that the both parties, at least two parties, free consent is needed, contractual capacity is needed, intention to legal relationship is must. So voidable contract is enforceable at the option of one party. One party charges, one party urges the demand of contract, but other party didn't give the free consent. Okay, so express contracts is made by the words oral or written. This is express contracts. Their validation and their depthness is less. Okay, implied contract is formed by conduct with activities. This is implied contract. Quasi contract is imposed by law to prevent unjust enrichment, unjust activities. Quasi contracts. Okay, so we are not digging the very depth in those. Just definition is enough for you. Breach of contract and remedies: when one party fails to perform their obligations, fails to perform their legal activities to the other party, this is a breach of contract. Okay, a supplier agrees. For example, a supplier, when the manufacturer contract with a supplier, that means the supplier is bound to provide those products, provide those raw materials to the manufacturer in a specific time, and with a specific price, and also with a specific quantity amount. Okay, so if the suppliers uh, don't don't do that, or fail to perform those responsibilities, obligations, that is they are breaching the contract. So all the time we cannot give the responsibility of breaching the contract to solely the supplier. We have to identify the context, okay, why the suppliers failed to do that. Yeah, so if it is the economic problem, or if it is the political problem, if it is there are different sort of hazardous comes to the point. So the supplier agrees to deliver goods by 1st June but fails to do so. This is a breach of contract. Okay. uh, Remedies for breach of contract: under the contract law 1872, the aggrieved party may claim the damage. Okay, what the damage, what the compensation will be for that damage. Okay, specific performance. The suppliers are bound to do a specific performance, that is they are bound to supply to the warehouse of that manufacturer, okay, the exact point, but they do not do it. They are responsible. All these statements will be under the law. Also, when the parties agreed upon different statements, then the law will be enforceable, right, at the very first point when the contracts is made. Okay. Injunction and rescission of contract. Then if the contract is valid, then with the courts, the specific remedies, specific performance will be performed by the both parties. Okay. Injunction and rescission of contract. If the judges or judiciary panel see that, or regulatory authority see that the contract breach of contract is this patterns, so the parties must fulfill the damage, must do that responsibility. This is how the rescission of contract may occur. School of legal thoughts. There are two types of approaches, two schools, two perceptions how the legal thoughts uh, are in the human mind. Okay, are in the logics and history. So some of the very important element are customs, history, and logic. Customs is the actions that is repeatedly occurring in the past and at present. Okay, so these are important elements to sue a person, to set legal boundaries. Okay, so customs, history, and logic, these the combination of these make good solutions for any contract, any breach of contract. The problem is the philosophers disagree on what are the major factors, and outcomes is the disagree has led to different schools of thought on what the major factors are. Because of these disagreements among the people, among the parties, there are two different thoughts came across, that is traditional approach and sociological approach. What are they saying? The traditional approach, they looks the past to discover what the principles of the current law should be. They only looks the previous incident, previous solutions to form any current law. Okay. So strict decisions are followed. Followers of this school look to prior decision, prior solutions which are on point, and will usually follow those accordingly at present and in near future. This is traditional approach. Okay. If we see that what sociological approach, their statement is, historical cases don't drive the future law. They think in a way that all the historical solutions should not be applicable as it is, as it was. Okay. Under this approach, as society changes, the laws, the regulations, the acts should change accordingly, obviously under the authority of regulatory bodies and under the society people. And the law should also change. Under this approach, the social host issue would probably have a different outcomes, because the court would see this as a public safety issue and would put them burden on individuals contributing to the occurrence, and provide a financial outlets for those who have been inquired. Okay, so since society is changing, so society's people's mind is changing, they think different scenario differently, they explain those scenario differently rather than the previous solutions. Okay, so the sociological approach states that these changes should be made, the laws also should change slightly according to the present view, present context. Okay. Company law in Bangladesh, in 1994, the governing company law of Bangladesh, a company is an artificial legal person created by law, and the company must have separate legal identity, that have separate a distinct company name, perceptual succession, and limited liability. Okay, you see that. There are public limited company, private limited company. They have the ability and they have the liability to its stakeholders, also the stockholders. Okay, and there are shares and the different uh, IPO system, initial public offering system, to collect the money, to collect the capital, to run that business. Okay, so number of shareholders also hold the responsibility and they have different obligations to the company. For example, ABC Limited is a company registered under the Company Act 1994. It is legally separate from its owners. That is, the owners have also other legal boundaries. Okay, the CEO, the MD, the employees have different boundary set of laws. The company is an distinct, separate legal identity which holds perpetual succession and limited liability to the society and the stakeholders. Now, the Sale of Goods Act in 1930 governs contracts relating to the sale of goods. Okay, how the products will be sold, how the trade will be conducted. It defines conditions, warranties, and transfer of ownership. Right, when we buy product, the ownership also changes, shifts. Right, the ownership also shifts. The sale of goods law governs transaction where goods are bought and sold for money. It sets the right and obligations of buyers and sellers. Okay, the key elements of a sale of goods. What are those? There must be a tangible goods when it is for goods, or when it is for service. These are intangible, right? Existing goods or future goods. Okay, in finance we see that future goods means that we have a number of products in finance, like future options. Okay, future hedging options. Okay, so these future goods, these future contracts will also be under the law of goods law goods law. Okay, sale of goods law. Price must be in money, not barter system. You know, the barter system where the exchange of product. Let's say if I provide 1 kg meat, then the other party will provide 2 kg rice. This is how the barter system works. Okay, so it should not be in that way. And this is very ancient mechanisms. Okay, so the price must be in money, currency. Transfer of ownership must pass from seller to buyer, and the both parties free consent is a must. Okay, for selling and purchasing a product. The consumer protection law is how the consumers and the consumers and the customers, their rights are protected under the Act of 2009. These safeguards consumers against unfair trade practices. Okay, the Directorate of National Consumer Rights Protection enforces the law. This is the regulatory authority, regulatory body. Okay, consumer protection law is designed to safeguard the interest of the consumers, interest of the customers. There are a slight difference between consumers and customers. Customers are only the buyer of that product. They might not be always, they are not the consumers. Okay, who consume that product, who take the benefits of that product. Sometimes customers are taking that product and repackage that, and then sell that product to the actual consumer. Okay, so safeguard the interest of consumers against unfair trade practice, defective goods, and deficient services. You see, there are sometimes we face defect products, unfair trade practice, the less quality products. Okay, so these are under consumer protection law. If if a consumer face this sort of breach of contract, they may sue it. Okay, a consumer is a person who buys goods, pays for them, he is the consumer, right? Objective is protect consumers from exploitation and unsafe products and ensure access to the information about the goods, about the service, how it should be used, how it should benefit the consumers, provide legal remedies for grievance, right? Okay. Role of business law in Bangladesh, you can go through it. Provide legal framework. Business law provide legal framework. They protect the rights of the stakeholders, stockholders. They protect the rights of the consumers. They facilitate trade. Okay, they facilitate the trade partners. Okay, they resolve disputes, resolve conflicts among the partners of this business. Encourage investment. Okay, when the investors see that there are a number of set of rules, set of laws, then the investors may find an encouraging scenario where they want to set a new venture, set a new investment opportunity, right? So investors are more willing to invest in a country with a strong legal protection, because they also seek the legal protection, seek the percentage of benefit. Okay, provide security regarding property rights, contracts, and company operations. And these regulates business ethics and accountability. All the business people should be accountable to the bosses, to the higher authority, regulatory body, to meet the standards, regulatory standards. So if there is business under business law, under several code of conducts, the bodies also feel safe, the investors also feel safe, okay, to run that business. There are several laws also, laws for taxation, environmental compliance, like the business is responsible for environmental pollution, environmental air pollution, sound pollution, blah blah blah. Okay, and the labor standards. Okay, this is the end of this chapter. We can start another small chapter. This is cyber law. I hope it will be good, because we don't have enough time to complete the whole syllabus in the physical class. So it's better to discuss the next chapter here. Okay. Cyber law. Cyber law is simple for you. Cyber law. Okay. So cyber law is producers helps to protect and secure individuals and organizations' information in the cyber related issues, right? When it is come to the ICT problems, when it's cyber security act, it needs cyber security act. Cyber law in Bangladesh is primarily governed by the Cyber Security Act 2023, that is replaced the controversial Digital Security Act in 2018. Okay, to address digital crimes, hacking, or online harassments, this better. It focuses on protecting digital infrastructure, digital protections, penalizing cyber offenses, while the Information and Communication Technology Act 2006, and this amended next time verified in 2013, also remains relevant. These acts, when it is modified, when it is updated than before, the statements, the courts also validates and further regulates, further analyzed, as is it okay for the changing environment, is it okay for should we enter a number of different contexts here. This is how the validation occurs, that this is how the updated versions come in at place, come as a code of conduct. Okay. Please remember that when we talk about the law contract, please keep it same as it is in the book. Okay. because laws, the statement of laws, we cannot change it. Okay, we cannot explain it exactly differently in our way. So it should be the exact same statement in the book. Okay, so Cybersecurity Act 2023, they reduces the severity of punishments for various cyber crimes while still providing legal mechanisms to manage digital security. I think you can go through these because these are very related with you, right? ICT issues and different acts. Okay, how these acts are updated. Okay, definition of cybercrime. You can go through it. I believe types of cybercrime in Bangladesh, use of internet in bad intention, Bangladesh in danger, the future of ICT or AI related issues. Okay, there are different cyber laws. I think you can go through it by your own. Okay, and I will also provide the books or materials from where you can learn and get the knowledge vastly. Okay, and I will provide those materials. Okay, so the next 16th February we have another quiz. What are the syllabus? What are the chapters? Can you remember the chapters? Listening and case study, most probably, right?
Yes, ma'am.
Huh? Mehdi, Miraj, are you there, Miraj?
জি ম্যাডাম।
Yes. তুমি কি এটা কনফার্ম করছো নাকি না অডিটোরিয়াম?
ম্যাডাম অডিটোরিয়াম হচ্ছে দুপুর 12টা থেকে হচ্ছে বুক করে রাখছি।
12টা থেকে না? আচ্ছা ঠিক আছে, 16 তারিখ।
জি ম্যাডাম।
হুম।
হ্যাঁ, হ্যাঁ।
হ্যাঁ, আমাদের সবার জন্য, মানে সেকশন এ এবং বি। হ্যাঁ,
হ্যাঁ, হ্যাঁ, হ্যাঁ, হ্যাঁ ম্যাডাম।
ওকে, ঠিক আছে, তাহলে তোমাদের আই উইল গিভ ইউ দ্য অ্যাটেন্ডেন্স ফর অল। ওকে, ওকে, দেন আল্লাহ হাফেজ, সি ইউ ইন দ্য ক্লাস or quiz. Inshallah, hope for the best and also pray for me.
আসসালামু আলাইকুম।
Okay, thank you. Allah হাফেজ, আসসালামু আলাইকুম।